Okay, let's just dive right in. We are looking at a story where the lines on a map, I mean the actual geometry of our democracy, have become this massive battleground.
Right.
It's law, it's partisan politics, and surprisingly, some really intricate math all rolled into one.
And this isn't just, drawing fair districts.
Hmm.
This is about power. It's about who gets representation and this fundamental question of how deeply race and party are tangled up in our system today.
Exactly. And the conflict at the center of this deep dive is this blistering emergency ruling from the Supreme Court. It just came down on December 4th, 2025.
And it's all about a new congressional map in Texas.
A map drawn in the middle of the decade, which is itself just, it's so unusual.
Oh, incredibly so. And it was drawn specifically with the 2026 midterm elections in mind.
The case is Abbott v. League of United Latin American Citizens, and it has forced the highest court to look squarely at whether you can get away with racial gerrymandering if you can just say your main goal was pure partisan advantage.
That's right. And our mission today is, it's a bit of a challenge because we have to wade through some really intense legal language in this emergency stay order.
Yeah.
We're going to try to separate the arguments from the court majority and the dissent to really understand what's happening here. We need to dissect how the court is using its own precedents or, maybe ignoring them to untangle race from politics.
And the real drama here is this clash of institutions, isn't it? You've got a 3-judge district court that spent months on this.
Months, a 9-day hearing, thousands of pages of records. They produced this incredibly detailed 160-page opinion that concluded, yes, race was the predominant factor here.
And yet, the Supreme Court, acting really quickly on an emergency basis, just decides to hit pause on that entire ruling.
It effectively wipes the lower court's finding off the board, at least for now.
At least for now.
And that leads us to the immediate outcome, the thing you really need to know up front. Supreme Court granted the stay.
What does that mean in simple terms?
It means that contested new Texas map, the one that district court said was unconstitutional, well, that's the map that will be used for the 2026 midterm elections.
Wow.
Period.
Wow.
So for the voters, the lines are set. The partisan advantage that this map was designed to create, it's locked in. Unless the full appeal, way down the road, somehow changes things.
It's a huge immediate win for the state of Texas and the people who drew this map.
A massive win.
So let's start with that big question of timing. Why are we even talking about a new Texas map in 2025? Redistricting is supposed to happen once a decade, right? After the census.
Right.
This whole mid-decade thing feels weird.
Yeah.
Almost destabilizing. What's the context here? What is this new normal?
It's more than unusual, you're right. It is a major destabilization of the whole electoral process.
Yeah.
Think about it. Normally, a state draws its map after the census, and that's it. Those lines are supposed to last for 10 years, unless a court steps in and says there's a constitutional problem.
But that's not what's happening.
No. The Supreme Court majority's order actually calls it the new normal. And what that means is state legislatures, usually where one party is firmly in control, are just redrawing maps whenever they want.
Specifically to get an edge in an upcoming election.
Exactly. To gain an edge right before a critical midterm, often because of some internal political calculation or, like in this case, some external pressure, Texas went first, targeting the 2026 elections, which, are always high stakes for who controls the House.
And other states followed.
Almost immediately. It's fascinating. The sources we have note that California rushed to pass its own map, and they were explicit about it. They were trying to counteract the gains they expected Republicans to get from this Texas map.
So it's like a redistricting arms race.
It is. And then North Carolina jumped in, too. It just accelerates the cycle. It creates massive instability. If every 2 years a state can just redraw its lines, you move away from any kind of predictable representation, and it just becomes this constant political chess match.
And what about the cost? For election officials, candidates.
Huge costs. And just massive confusion for voters who suddenly find themselves in a new district with a new representative, 2 years after they just figured out the last one.
So let's talk about the Texas trigger then. As you said, this wasn't initially a court-ordered change. What happened? What made Governor Abbott go from kind of resisting this idea to suddenly calling for a whole new map?
So the initial push, and the dissent lays this out in meticulous detail, it was purely political. It came from the previous administration, the Trump administration.
Just a push for more Republican seats.
A simple push to create more Republican seats, shore up the majorities they had. But that political campaign, it didn't really get much traction. We know this because a state senator, Joan Huffman, testified in June of 2025 that the legislature wasn't even considering touching the map.
And the governor.
Governor Abbott called a special session that month, but he pointedly left redistricting completely off the agenda. So the political pressure had stalled out.
Okay, so the key thing here is that pure partisan politics wasn't enough. It didn't work. Something else had to happen to get this going.
That is exactly right. And the crucial moment, the point where this whole thing pivots from just partisanship to this racial imperative, happened on July 7, 2025.
Okay.
The DOJ Civil Rights Division sends a formal notice to Texas officials. And in it, they express serious concerns regarding the legality of 4 of Texas's congressional districts. This letter gave the state the legal pretext it had been missing.
This is where that legal misstep or maybe misrepresentation from the DOJ comes in, right? The dissent really hammers this point.
Oh, they hammer it hard. Because the DOJ letter focuses almost entirely on the racial makeup of these 4 districts.
Sure.
It describes them as coalition districts.
Can we just define that really quick? What's a coalition district?
Yeah, of course. So a coalition district is one where you have 2 or more minority groups, say Black and Hispanic voters, and together they form a majority of the voting age population.
So they can elect their candidate of choice, even if neither group alone is over 50%.
Precisely. It's often a necessary tool in really diverse areas to ensure minority representation.
And yet the DOJ letter basically called them illegal.
It made what the dissent calls a fundamental legal error. The DOJ letter claimed, and I'm quoting here, "It is well established that so-called coalition districts run afoul of the Voting Rights Act and the 14th Amendment."
Which is just not true.
It is just false. Coalition districts are recognized by the courts. They're a legitimate way to comply with Section 2 of the Voting Rights Act. But the letter wasn't framed as a suggestion. It was an ultimatum.
It was a demand for a racial rectification.
Yes. The DOJ insisted these districts must now be corrected and rectified immediately by the legislature, and they threatened to sue if Texas didn't comply.
Okay.
That just transformed the entire political dynamic.
So nobody today is defending the idea that coalition districts are illegal, but that
letter, by reframing this political desire for new lines as a mandatory legal necessity involving race, it provided the perfect cover, the perfect justification for the legislature to act.
And that timing is it's so damning, especially in the eyes of the district court. Just 2 days after getting that legal threat, Governor Abbott's whole attitude changes.
A complete 180. He issues a proclamation, adds a new item to the special session agenda, legislation that provides a revised congressional redistricting plan in light of constitutional concerns raised by the U.S. Department of Justice.
So he's explicitly citing the DOJ's constitutional concerns.
He is. And the district court used that timeline as powerful direct evidence. They said, look, the legislature isn't responding to that old political request from the Trump folks anymore. That had stalled. They are responding specifically to the DOJ's demand for racial compliance.
And what was the end result?
The result was a brand new map, enacted by late August. And the dissent points out that this map did 2 things perfectly. It secured 5 more Republican-leaning seats, and it achieved all but one of the racial objectives the DOJ demanded.
So it dismantled those coalition districts.
Systematically. Dismantled them, left them unrecognizable, and replaced them with districts drawn specifically around single-race majorities. And that tight transactional timeline, that's what formed the bedrock of the district court's conclusion that race, even as it was masked as legal compliance, had become the real predominant factor in drawing these lines.
So when the plaintiffs, the League of United Latin American Citizens and others, challenged this new map, the case goes to that 3-judge district court. Before we get into what they found, I think we really need to emphasize just how much work they did here, because it feels like the Supreme Court majority sort of glossed over it.
It was an incredible undertaking. This wasn't, some quick decision. It was a deep, granular fact-finding mission.
Right.
The district court held a 9-day trial. They heard detailed testimony from nearly 24 witnesses. They reviewed thousands of exhibits, and they put together a factual record that was over 3,000 pages long.
And all of that resulted in a 160-page opinion.
A 160-page opinion, which is it's almost unheard of in this kind of emergency redistricting litigation.
Yeah.
They were incredibly thorough.
And their entire analysis was built around proving a violation of the core legal standard for a racial gerrymander claim. What exactly did the plaintiffs have to prove?
They had to prove that race was the predominant factor motivating the drawing of the lines. The law here, under the 14th and 15th Amendments, is pretty clear. A state cannot separate its citizens based on race unless there's some kind of compelling justification.
Which Texas didn't even try to claim they had.
No, they didn't. The real challenge, and this is confirmed in cases like Cooper v. Harris, is that even if your ultimate goal is partisan, if you use race as the means to get to that partisan end, it's still unconstitutional.
So the district court had to prove that the means using race to draw the lines was the main thing, even if the ultimate goal was just to get more Republicans elected.
Exactly. They were looking for evidence that the map makers prioritized racial demographic data over all the traditional race-neutral things like, keeping cities together, following county lines, or even just looking at pure partisan data.
And the district court found that evidence to be
Clear-cut. That was their word. They organized their whole conclusion around 3 different types of direct evidence that they found cumulatively strong enough to overcome that legal presumption that the legislature was acting in good faith.
Okay, let's go through them. The first type was the racial framing that came from the DOJ.
Right. The court saw that DOJ letter as the moment Texas was essentially directed to engage in racial gerrymandering.
How so?
Well, they reasoned that the only way you can remedy these supposedly objectionable coalition districts, where no single racial group had a majority, was to draw new lines precisely to ensure a single racial group did hit that 50% majority mark.
So the mandate itself forced them to use race as the primary tool.
The court concluded that it forced the map makers to operate under a racial lens from day one. The job wasn't find the best way to elect a Republican. It became find the best way to draw a 50% plus Hispanic district or a 50% plus Black district.
And the second type of evidence was the governor's rhetoric, which kind of locked in that intent.
Yeah, this was really powerful testimony because it was coming from the state's chief executive. The district court noted that Governor Abbott, right after that DOJ letter came out, consistently talked about the new map in racial terms. He said the map was drawn to convert coalition districts into majority Hispanic or majority Black districts. He even explicitly said they wanted to provide more seats for Hispanics.
And this is where that link to partisanship comes out, right? He was claiming he was drawing Hispanic seats, but they just happened to be Hispanic Republican seats.
Exactly. He was very careful. He rejected the idea that Texas was just doing this to fulfill the Trump administration's demand for more Republican districts.
Right.
No. He framed the partisan outcome as just a happy coincidence. More Hispanics are simply aligning with Republicans, but the focus of the drawing process was racial.
And that verbal framing was proof for the district court.
For them, it was proof that the legislature and the governor were prioritizing racial outcomes, even if the secondary benefit they wanted was partisan.
The third type of evidence, the legislative strategy, that gets to the intent of the map drawers themselves. And the quote the court found is it's pretty striking.
It's as close to a smoking gun as you're likely to get in these cases. The district court found that the bill's backers strategized that a map that eliminated coalition districts and increased the number of majority Hispanic and majority Black districts would be more sellable than a nakedly partisan map.
Wow. So they said it out loud.
It was a conscious, documented political choice. Use the appearance of Voting Rights Act compliance as the vehicle, the means to achieve the partisan advantage they wanted. They used race as the main drawing tool because they knew a purely partisan map would be much harder to defend, both politically and legally.
So beyond the direct statements, there's the circumstantial evidence, the numbers. Let's talk about the statistical outcomes of the map because that might be even more persuasive. Tell us about CVAP and the specific figures.
Okay, so this is where the math becomes really critical evidence. First, let's just clarify the metric. It's citizen voting age population, or CVAP.
Right.
Mapmakers use CVAP because it only counts citizens who are old enough to vote. This is the key group for measuring actual political power and representation, not just total population, which includes kids and non-citizens. Using CVAP allows mapmakers to be incredibly precise if they're trying to hit a certain target.
And the district court found that this new map hit that 50% CVAP target over and over again.
By margins so thin, they strained credulity. 3 of those targeted coalition districts were converted into single-race majority districts, but just barely. One went from about 25% Hispanic CVAP to 50.3%.
Just over the line.
Another went from around 38% Black CVAP to 50.5%, and a third went from 46% Black CVAP to 50.2%.
Hitting that 50% mark, sometimes by just a fraction of a percentage point, that feels statistically improbable. I mean, if you're just drawing lines based on party or geography, they should be a lot messier than that.
They absolutely should. The district court found it was very unlikely that the mapmaker would have hit a barely 50% CVAP 3 times by pure chance.
Mm.
especially since he had software that could track this racial data in real time as he was drawing.
And what did the map maker say?
Well, he testified under oath that he hadn't used the racial data. And the district court, they basically said they didn't believe him. They questioned his veracity and explicitly discredited his testimony.
So they call him a liar.
They concluded it was far more plausible that he used the racial data to hit those specific racial targets that the DOJ and the governor had announced, while also using partisan data to achieve his political goals.
Okay, but hold on a second. If the map maker testified under oath he didn't use the racial data, and the state legislature says our only goal was partisanship, why doesn't the Supreme Court have to accept that? What about that presumption of legislative good faith? Isn't that the whole point?
That is the exact tension that the Supreme Court majority later seized on. The district court acknowledged the presumption, but their finding was that the evidence, the rhetoric, the timing, and the statistical impossibility of hitting those tiny margins was so overwhelming that it just crushed the presumption.
So it wasn't just a correlation, it was intent.
For them, it was clear intent to use race to create those specific 50% majorities. To the district court, the mapmaker's denial was it was simply implausible when you're looking at a 50.2% outcome.
And there was a final piece of evidence, right? The expert testimony.
Yes. An expert for the plaintiffs generated tens of thousands of hypothetical maps. All of them were drawn to favor Republicans, but they followed strictly race-neutral criteria.
And what did they find?
The finding was devastating for the state's defense. Not one of them had racial demographics that look anything like those in the 2025 map. Basically, if you draw a map for pure partisan advantage, you get one set of racial outcomes. If you draw a map to hit specific 50% racial targets, you get another. And the Texas map looked exactly like the second one.
So, despite this incredibly exhaustive fact-finding process, a 9-day trial, discredited testimony, compelling statistics, the Supreme Court majority still decided that Texas was likely to succeed on the merits of its appeal.
Right.
Which means they must believe the lower court made some serious, fundamental legal errors that just negated all of that work.
That's precisely the mechanism they used. To grant a stay like this, which is a pretty big deal, they had to argue that the district court's detailed opinion wasn't just, factually debatable, but that it was legally flawed. The majority pointed to two core errors, both related to established precedent on how you're supposed to handle cases where race and politics are all mixed up.
Okay, let's start with error number 1, the presumption of legislative good faith.
The majority argued that the district court just failed to honor the presumption of legislative good faith. This is a bedrock principle in law. Courts have to assume that legislators are acting constitutionally, even when the evidence isn't perfect.
So the majority is saying the lower court was too quick to assume the worst.
Yes, they claimed the district court erred by construing ambiguous, direct, and circumstantial evidence against the legislature, which goes against a recent precedent in a case called Alexander v. South Carolina.
So when the governor said he was drawing Hispanic seats, the majority's view is that the district court should have interpreted that ambiguously.
Exactly. They're saying maybe he just meant he was drawing seats that would likely elect Hispanic Republicans, which is a partisan goal, not a racial one.
It's a fine line.
A very fine line. The majority viewed all that racially tinged language and those razor-thin statistics not as conclusive proof that race was the main factor, but just as a correlation between race and partisanship, which in many cases is legally okay.
So by drawing the inference of racial intent, the majority said the district court failed the extraordinary caution test.
Right. And that really sets the stage for their biggest disagreement.
Which brings us to the real legal heart of this decision, error number 2, the alternative map requirement. This feels like the technical move the majority used to get around the district court's factual findings.
This is the critical pivot point. The majority found that the district court failed to draw a dispositive or near dispositive adverse inference against the challengers because the challengers didn't produce a viable alternative map.
Okay, what does that mean? What's an alternative map and why is it so important?
So this requirement comes directly from that Alexander case. The logic is, when a state claims its motivation for drawing a district was purely political, which Texas did, the court needs some way to disentangle race and politics. They're often very closely linked.
And an alternative map is the tool to do that.
It's supposed to be the only real counterfactual. If the challengers could have produced a different map that achieved the exact same partisan outcome, let's say securing 5 new Republican seats, but did it while following race-neutral criteria and avoiding those weirdly precise 50.2% margins, then that would prove that race wasn't necessary.
It would show the state chose to use race instead of just letting it correlate with party.
Exactly. So since the challengers failed to produce a map that served the state's partisan goals just as well, the majority inferred that the state's claimed partisan motivation must have been the true one.
This argument is laid out most clearly in Justice Alito's concurrence, right? He basically says, look, this was all about politics from the start.
Yes, his points were decisive for the majority. He framed the whole issue by stating that the undisputed reason for this map was partisan advantage, pure and simple. That establishes politics as the default explanation.
And then he gets into why the Supreme Court can even overturn the district court's factual findings without violating the clear error standard of review.
Right, because that's a huge hurdle. Appellate courts are not supposed to reweigh facts found by a trial court. You can't just say, we disagree that the map maker was lying.
So how did he get around that?
Justice Alito provided the legal key. He argued that the clear error standard of review does not apply here. Because, he said, the trial court based its findings upon a mistaken impression of applicable legal principles.
Can you just boil that down for us? What's the difference between a clear error and a mistaken legal principle? Is the Supreme Court basically saying, we don't care about your facts, you used the wrong calculator?
That's a perfect analogy. Under clear error, the Supreme Court has to accept all the trial court's facts, the governor's words, the discredited testimony, the 50.2% numbers, unless they are just completely illogical.
Okay.
But by using this mistaken legal principle loophole, Justice Alito is saying, your facts might be correct, but the legal framework you used to interpret those facts was wrong. Specifically, he claimed the district court failed to understand the super high burden that Alexander places on plaintiffs to disentangle race and politics with an alternative map.
So because the D.C. used the wrong standard, the Supreme Court gets to look at the evidence fresh.
Yes, de novo. As if the 9-day trial never happened. It's a procedural move that allows them to legally disregard the entire 3,000-page factual record without having to say the governor was telling the truth or the stats were wrong.
It's a profound shift.
It is. It effectively elevates the absence of an alternative map above every other form of evidence, even direct evidence of legislative intent.
And finally, the majority also touched on the idea of irreparable harm, using the Purcell principle to say that stopping the map now is just too close to the election.
Right. They cited the rule that federal courts should not alter the election rules on the eve of an election. They accused the district court of improperly inserting itself into an active primary campaign and said forcing Texas to use the old map now would cause chaos and irreparable harm.
So the dissent, written by Justice Kagan, it's a ferocious rebuttal. It basically argues the majority committed a massive judicial overreach by just substituting its own judgment for the trial courts.
Ferocious is the right word. The dissent starts by emphasizing the singular deference that is owed to that three-judge panel. They stress that the standard of review for these factual determinations, especially on whether race was the main factor, is the demanding clear error standard.
Meaning the ruling has to be upheld if it's even just plausible.
If the district court's finding is merely plausible in light of the full record, and given the mountain of evidence they had, the dissent argues their finding was, at a bare minimum, plausible.
There's a procedural complaint here too, right? The dissent has this sharp line about the majority reversing the ruling based on a perusal over a holiday weekend of a cold paper record.
The very pointed jab. They contrast that with the trial judges who actually sat there for 9 days and assessed the credibility of 23 different witnesses.
So it's a direct accusation.
It's a direct accusation that the majority arrogated to itself that court's rightful function. The dissent believes the only way the majority could have reached its conclusion was by ignoring the trial court's assessment of who was credible and who wasn't.
Let's tackle the legal errors the majority identified, starting with the first one, the presumption of good faith. How did the dissent defend the district court's conclusion there?
So the dissent counters by arguing the district court did acknowledge and honor the need for extraordinary caution. The trial court explicitly said it would draw the inference that cuts in the legislature's favor whenever the evidence was ambiguous. And in fact, they did find certain statements to be too ambiguous to rely on.
But not all of them.
But not all of them. The dissent stresses that, at the end of the day, the district court found that the sheer volume of evidence, the specific legislative strategy to make the map more sellable, the governor's constant racial framing, the statistical impossibility of the numbers, was so substantial that the presumption was overcome.
Right.
As Justice Kagan put it, presumptions, after all, can be simultaneously honored and overcome.
Yeah.
The issue wasn't that the district court ignored the presumption. It was that the majority just disagreed with the conclusion that the state's actions were bad enough to defeat it.
Now for the big one, the alternative map inference. This is where the interpretation of that Alexander case really clashes, and where the dissent levels its sharpest criticism.
This is the absolute core of the legal conflict. The dissent points out that the district court did draw an adverse inference from the lack of an alternative map. They acknowledged it. However, and this is crucial under Alexander itself, that adverse inference only becomes dispositive, meaning fatal to the plaintiff's claim, in cases where the plaintiff lacks direct evidence.
And since the district court found substantial direct evidence,
They concluded the failure to produce an alternative map was not fatal. Precisely. The dissent quotes the district court directly. Quote, "Unlike the challengers in Alexander, who provided no direct evidence of a racial gerrymander, the plaintiff groups here have produced substantial direct evidence."
so based on the precedent's own language, a racial gerrymander could be found here.
Exactly. The majority, by elevating the alternative map requirement above all that direct evidence, was essentially changing the law on the fly.
And this brings us to that exceptionally pointed criticism about the majority's language, the term near dispositive.
Yes, this is where the dissent basically suggests the majority is just making things up. The dissent notes that the term near dispositive does not appear in Alexander or any other relevant Supreme Court decision on this topic.
So it's a new legal standard.
It was, in the dissent's view, an invented term made up for the occasion to justify elevating the alternative map requirement. This effectively raises the bar for challengers in a huge way, and they did it through a rushed emergency order.
So the dissent is implying that the majority's whole claim that the district court operated under a mistaken impression of applicable legal principles was just a pretext, a way to get around the clear error standard and overturn a factual finding they didn't like.
That is exactly the implication. The majority was able to reinterpret all the legislative statements, all the statistics, and the mapmaker's testimony, and substitute their own judgment that it all just pointed to partisanship. If they had been bound by clear error, they would have had to uphold the district court's findings. The procedural maneuver was the whole game.
Okay, finally, let's look at that crucial timing issue. The Purcell principle and the eve of an election argument. The majority said the injunction would cause irreparable harm because it was too close to the vote.
And the dissent just fiercely challenged this. They argued Texas was emphatically not on the eve of an election. The majority cited a case from 2020 where the election was 5 days away. Here, Election Day was 11 months away.
11 months.
And even the March primary was still months away.
Yeah.
The dissent argued that applying Purcell in this situation just completely misreads the purpose of the doctrine, which is meant to prevent last-minute chaos when, ballots are already being printed or early voting has started.
And the district court itself actually explained why the disruption would be minimal.
They did. They wrote that reinstating the old 2021 map would not cause significant disruption.
Okay.
And crucially, that 2021 map was the status quo. Voters and officials were already familiar with it. It was even still being used in a special runoff election in January 2026.
So the argument that the 2026 election was well underway just didn't hold up for them.
No. And this leads to the fundamental structural problem that the dissent raises. This ruling creates kind of catch-22 for anyone trying to fight gerrymandering.
What do you mean?
Well, the dissent calls it a free pass. If Purcell applies this far out from an election, it allows a legislature to implement even a blatantly unconstitutional map just by strategically timing when they pass it.
Right. Texas passed this map just a few months before the district court ruled.
Exactly. If a state can just wait until primary preparations are getting close, say, 6 months out, and then use Purcell as a shield from judicial review, the courts effectively lose their ability to uphold the Constitution.
So if you challenge a map too early, you lose because the claim is premature. But if you challenge it later, after the legislature has slow-walked it, the Supreme Court just says, you're too late.
It completely boxes the challengers in. It suggests that our court system can no longer provide a timely remedy against constitutional violations in redistricting, especially when the state itself controls the clock. So to synthesize all this, I think the core takeaway from this deep dive is this. This case just demonstrates how incredibly difficult it is to prove racial intent when it's so closely correlated with partisan intent. It shows the extremely high burden now placed on challengers to disentangle race and politics.
And the court gave them a very specific and very difficult tool to do that.
A very difficult tool. By focusing so heavily on the absence of an alternative map, and by using that legal maneuver to say the district court was operating under a mistaken legal principle, the Supreme Court majority was able to just legally override these detailed, fact-based findings of unconstitutional racial gerrymandering.
And for the judiciary as an institution, I mean, this case raises some serious questions about the proper standard of review, right? By basically substituting its own judgment for that of the trial court, a court designed for exactly these complex cases, the Supreme Court is really challenging the traditional balance of power.
Especially when it's acting on an emergency basis with a limited record. But the immediate practical result is undeniable. The new Texas map, the one the trial court found was achieved through intentional racial sorting, that's the map that will be used in the 2026 House elections.
So that outcome is locked in, the partisan advantage is guaranteed, and the process that the lower court called a constitutional violation has been validated, at least for now.
It has.
And that leads us to a final provocative thought for you to think about. This whole disagreement over the timing, over the Purcell principle, it reveals this huge structural tension in our election law today. If, as the dissent argues, legislatures can strategically time the passage of new maps, essentially using the calendar itself as a shield against scrutiny, how can our courts ever truly uphold constitutional protections against gerrymandering without constantly being accused of improperly inserting themselves into the election process? The battle here wasn't just over the lines on a map, it was over the schedule of justice itself and who gets to control it. And that question is going to define the future of election.